Okay, thank you. Good morning to all of you in Toronto. It's a pleasure for me to be able to sit in Jerusalem and speak to you there. I'd like to thank the sponsors, Universe and Scotiabank, and everyone else who's made this possible, and regards to my father, who I can't really see, but I believe he's sitting there amongst you. There are a number of features in the Israeli succession law regime which will be of interest to Ontario practitioners. Chuck has mentioned a specific fact situation, which we'll get to in a moment. The features of the Israeli succession regime are such that they may create some very bizarre and interesting scenarios, which may create pitfalls or opportunities. So it's worth to spend a few minutes going through some of those issues. I repeat some, not all of them. And then we'll apply them to the situation of Max and his daughter. I don't think I need to go on the fact that we're only covering things in a very quick and rough fashion here. And you can see the paper for more details. Israel has a network of estate registrars who work hand in hand with the family court, and they're basically agents of the public guardian in Israel. They handle the estate matters. It's possible to go to rabbinical courts, but we won't discuss that now. The process with the estate registrars is bureaucratic. It takes months, sometimes years, to get probate. The first question that a state registrar will ask himself when somebody asks probate, like Mr. Shaman, he'll ask if he has jurisdiction. Chuck mentioned the situation in Ontario. Under Israeli law, Israeli courts have jurisdiction in one of two cases. One, that the deceased was domiciled in Israel, and two, if the deceased left property in Israel. Number two is somewhat controversial. I can paraphrase one of the judgments of the court, or a statement of the court. They said basically, if anybody leaves a pair of, or some old clothing in Israel, he's left property in Israel. The Israeli courts will claim theoretical jurisdiction over his estate, and I mean his estate everywhere in the world, land, movables, no matter what. The next question that the court will ask itself, after it decides it has jurisdiction, is whether the Israeli forum is the convenient forum. In the case I described, where the person left a pair of some clothing in Israel, obviously Israel will not be a convenient forum. But it should be noted that Israeli courts tend to be very assertive when it comes to claiming jurisdiction, and they put the burden of proof on the person who's denying jurisdiction to prove beyond a doubt that the Israeli forum is not a convenient one. I'll describe one case just to give a picture that we can have in our mind. A few years ago, there was a very wealthy tycoon from Ecuador. He lived in Ecuador. He had a wife, became his widow in Ecuador. He had his children in Ecuador. They ran his business. Almost all of his assets were outside Israel. He had one daughter who lived in Israel. He had an apartment in Israel and some money in the bank. The Israeli court, at the request of the daughter, assumed jurisdiction of his entire estate all over the world. Naturally, the heirs in Ecuador objected, but it went to the Supreme Court of Israel, which affirmed that the Israeli courts have jurisdiction in such a case. Another question that may come up from time to time is the capacity of the testator. I don't think we have to really deal with that issue in our case, but I'll just mention that the Israeli courts will look at for deciding whether or not the testator had proper capacity, they will look at the law of the jurisdiction in which he was domiciled at the time he made the will. The next question that comes up is the question of the formal rules when a will is signed and witnessed. And that's really the main feature of this case that Chuck described. Under Israeli law, a will is valid if it complies with the formal rules of Israel or a number of other jurisdictions, such as residence, domicile. But since Israeli rules are so flexible, we'll concentrate on the Israeli rules. Formally speaking, when somebody signs a will in Israel, he has to do it. The will has to be in writing. The will has to contain a date. There has to be a declaration by the testator in front of two witnesses that this is his last will. The witnesses have to sign. The testator also signs, of course, and the witnesses have to, on their declaration, say that the formalities I've just discussed have been complied with. That sounds strict. It sounds something like the situation in Ontario, but a case law and recent amendments to the Israeli legislation indicate that the court can ignore almost all the defects. What's really required now is just that the testator come with his will, in front of two witnesses, tell them that this is his last will and testament. They see it, they don't even have to sign. Even the testator doesn't have to sign. Theoretically, an Israeli court can ignore the defects. There's a question of presumptions. If a will is signed and fits all it complies with all the formalities, the Israeli court will assume that the will represents the testator's last wishes. If there's a defect, then the person who's applying for probate will have to bring some evidence to show that indeed, despite the defect, the will does represent the testator's last wishes. There is case law suggesting, it's not an actual decision, but suggesting in the Supreme Court that even if there's one witness, courts may, in certain cases, validate such a will. Clearly, the situation in Israel is much more liberal than in Ontario. Just in passing, I'll to note that in certain other matters, the Ontario legislation is more liberal than Israel. For example, if a beneficiary signs a will or helps in preparing the will. In Israel, the Israeli law is pretty merciless. That such a beneficiary will just lose his share. The next question that comes up is which law is applicable to the estate. If we have intestacy, what rules of intestacy? Even though Israeli courts will claim jurisdiction, nevertheless they will decide the case in accordance with law of the domicile of the deceased, where he died. So in the case of the Ecuadorian tycoon, even though Israeli courts have assumed jurisdiction, they will apply Ecuadorian law. Ecuadorian law experts will come and testify as to the law in Ecuador. Just to review before we apply it to our case at hand, jurisdiction, Israeli courts will take jurisdiction if the testator is domiciled in Israel or if he's left property in Israel. Convenience of the forum is an issue, but Israeli courts are quite assertive. Capacity, the law of domicile of the testator at the time he made his will. The will formalities, a number of possible jurisdictions, but Israeli law is very forgiving, so we can assume that the will follow Israeli law and be accepted. And in terms of construction of the will, interpretation, or issues of intestacy, will follow the jurisdiction of domicile of the deceased. Let's quickly apply it to the case of Max. Max lived in Israel. He has property in Israel. The Israeli courts will accept jurisdiction. It's pretty clear that the Israeli courts will say that the Israeli court is a convenient jurisdiction. Capacity is not an issue. It looks at formalities. The daughter will have to bring the witnesses who saw the signature, as the two didn't sign. She will have to bring affidavits from the family court. It's likely that she will get a probate. I should note that, generally speaking, probate orders in Israel are limited to Israeli assets. But as we've seen before, the law allows Israeli courts jurisdiction over the entire estate outside Israel. All Shoshana will have to, that's the daughter, she will have to ask the court to give a probate order covering not only Israeli assets, but also the assets in Ontario. So if we can sum up, we can say with a great deal of certainty that Shoshana will get a probate order. In passing, I'll mention that she needs it here because there's no way that Israeli courts will reseal orders from outside of Israel. There's one recent decision that indicates in certain circumstances that may happen, but generally speaking, the court will not even consider such a proposition. So we have now Shoshana with a probate order some months down the road, and the question is whether you can reseal that order in Ontario. I turn over at that. Okay. Back to you.
Thank you. My associate Rafi Soto has put up two more sections for our review from the Succession Law Reform Act. And I will confess to you, when I first started this paper, I wasn't entirely clear on how to approach it. So I spoke to Archie Rabinowitz, who I always speak to when I have a question on these matters. I spoke to Jordy, and I spoke to Tim Uden and Elena Hofstein to get an idea on how to deal with this complicated matter. And in conflict of law situations, it is very complicated. So let's first take a look at the legislation, which is always a good place to start. Under the Succession Law Reform Act, which is the legislation in Ontario that deals with these matters, we go to Section 36, and let's just review it. The manner and formalities of making a will and to its essential validity and effect so far as it relates to an interest in land are governed by the internal law of the place where the land is situated. So at first glance, when it deals with the land in Ontario, it seems clear that Section 4 governs. That means full compliance with the formalities of execution. Max owns 2 properties here. So if he wanted to get probate, the court would say the law of Ontario governs with respect to the land, no probate. That's your first step. Of course, your first step should never be your last step. When it comes to movables, it's where the testator was domiciled. So with respect to the $2 million cash that he had at the TD at Bathurst and Wilson, and as again I say, North Insgezocht, if with respect to that cash, he was the law of Israel would govern with respect to the formalities. And as Michael explained to us, the Israeli law is a lot more forgiving, substantial compliance. But if we stop there, we wouldn't have the full answer. We have to go to Section 37. And Section 37 says, as regards the manner and the formalities of making a will of an interest in movables or in land. So it's both respect to the properties in Toronto, the land, and the cash. A will is valid and admissible to probate if at the time of its making it complied with the internal law of the place where the will was made. Meaning, if Max was domiciled in Israel, which he was, and he made the will in Israel, which he did, and he complied with the formalities of execution, which he did, then the law is valid, the will is valid in Ontario. And because the will is valid under Ontario law, a one-witnessed will could be probated in Ontario. Right? Maybe. Because there's another provision, a key provision, that we have to remember. It says, if at the time of its making. Was the will valid in Israel at the time of its making? Or was it, alternatively, validated by an Israeli court later? You see, there's a big difference if automatically you know the premise is the will is valid, right? 2 witnesses, will's valid. But if it has to be validated later, if Shoshana, his daughter, the executrix, has to come to court in Israel, bring affidavit evidence, and say, Your Honor, this is really the testator's intent. Was it valid at the time the will was making? That's the key question an Ontario court will answer. So how do we respond? We have to ask the question, was it valid at the time of its making? Michael?